Biomedical Research Institute, and 3 others, are stated as follows. And we quote from paragraph 47 of that judgment. It says, "It is a timeless rule of the common law tradition, Kenya's juristic heritage, and one of fair and pragmatic conception, that the party making an averment in validation of a claim is always the one to establish the plain veracity of the claim. In civil claims, the standard of proof is the balance of probability. Balance of probability is a concept deeply linked to the perceptible fact scenario. So there has to be evidence on the basis of which the court can determine that it was more probable than not that the respondent bore responsibility in whole or in part." This position was reiterated by the Supreme Court in Wamwere and others versus the Attorney General, and we have cited the holding of the Supreme Court. We said a petitioner bore the burden to prove his or her claim of the alleged threat or the violation of the rights and freedoms of the requisite standard, which was on a balance of probabilities. Such claims were by nature civil causes. The onus of proof was on the first appellant to adduce the sufficient evidence to demonstrate that she owned or erected or lived in the alleged properties, and that state agents interfered or deprived her of the subject properties. That was the import of Section 107 of the Evidence Act on the burden of proof. End of quote. We further cite the decision in the Council of County Governors versus the Attorney General by the mastivo judge, as he then was, and I will not read that, but we have lifted a bit of the ruling on the general presumption that every act of parliament is constitutional and the burden of proof lies on every person who alleges otherwise. Further, in the East African Court of Appeal, in the case of Danambo versus the AG, the court held that the Constitution is a living instrument having a soul and a consciousness of its own. Courts must endeavor to avoid crippling it by construing it technically or in a narrow spirit. It must be construed in tune with the lofty purpose for which its makers framed it. Fundamental rights have to be interpreted in a broad and liberal manner, ensuring that our people enjoy their rights. Our young democracy not only functions but grows, and the will and dominant aspiration of the people prevail. End of quotes. The guiding principle in determining whether the sections of an act of parliament are unconstitutional were succinctly laid out in the case of Institute for Social Accountability and another versus the National Assembly, where a three-bench of this court held as follows. First, that this court is enjoined under Article 259 of the Constitution to interpret the Constitution in a matter that promotes its purpose, values, principles, and advances rule of law, human rights, and fundamental freedoms in the Bill of Rights, and that contributes to good governance. In exercising its judicial authority, this court is obliged under Article 159 of the Constitution to protect, promote the purpose and principles of the Constitution. Additionally, we also looked at the petition of number 150 of 2016, which was consolidated with petition number 234 of 2016, Attorney General, EG and others versus Attorney General, where the three-bench judge held that the technique of paying attention to context in statutory construction is now required by the Constitution. As pointed out earlier, the Constitution introduced a mandatory requirement to construe every piece of legislation in a manner that promotes the spirit, purport, and object of the Bill of Rights. The purpose of statute plays an important role in establishing a context that clarifies the scope and intended effect of a law. The often quoted dissented judgment of Schreiner J.A. eloquently attributes the importance of context in statutory interpretation thus, and he went on to say that certainly not less important than oft-repeated statement that the words and expressions used in a statute must be interpreted in according to their ordinary meaning in the statement, and that they must be interpreted in light of their context. But it may be useful to stress 2 points in relation to the application of this principle. That first is the context as here used is not limited to the language of the rest of the statute regarding as throwing light of a dictionary kind or of the part to be interpreted. Often of more importance is the matter of the statute, its apparent scope and purpose, and within limits its background. We further cited the case in SBM and another versus the Attorney General. It's a Supreme Court decision that states that it's unassailable that the approach to interpreting fundamental rights and freedoms in the Bill of Rights by this court has to take the model of looking at the Constitution as a whole, which is purposive and generous, giving effect to the constitutional values, including substantive equality. In reaction to inequality and discrimination advanced by the petitioner in Prince Law versus this is a South African decision, where the court said it is convenient for descriptive purposes to refer to the differentiation presently under discussion as mere differentiation. I'll not quote the end of that ruling, but I'll go to the next broad issue. Under the broad issue of constitutionality, we identified the following points for determination. 1, whether there was adequate public participation. 2, whether the Affordable Housing Act violates Article 27 and 40 of the Constitution. 3, whether the Act infringes on Article 43 of the Constitution. 4, whether or not the Act amounts to a clawback on devolution. 5, whether the use of public land for development of affordable houses infringes on the functions of the National Land Commission. And 6, whether the Act is unconstitutional for failure by the CRA to consider the bill as per Article 205(1). On whether public participation was undertaken, the petitioner has argued that the enactment of the Act was not done in conformity with the various tenets of the Constitution, one of them being public participation. While they concede that some measure of public participation was conducted, it was their submission that it was not sufficient. It was therefore their case that at best, what was done was a cosmetic exercise and a waste of public resources. The petitioner has argued that whatever was done by way of public participation went contrary to Articles 10, 118, and 201 of the Constitution. In particular, the petitioner has argued that the invitation notice to members of the public to present memoranda on the bill by the National Assembly within 7 days. Similarly, they contend, and thus the purpose of public participation cannot end, and third reading stages was also constrained with the result that limited public participation, it limited public participation to 7 days only, such that no public hearings could be conducted in any of the 47 counties. The petitioners also took issue with the fact that public participation was only conducted in 19 counties. They pointed out that 28 counties were excluded from the exercise in blatant violation of Article 10(1), 2A, and 27 of the Constitution. That the discrimination of the petitioners went further to state that the discrimination of the 28 counties and the refusal by the committee mandated with the conducting public participation or collecting views of the persons from the 28 counties was in blatant disregard of Article 47 of the Constitution of Kenya 2010, as read with Sections 4 and 5 of the Fair Administrative Act 2015, that require administrative action to be expeditious, efficient, reasonable, and procedurally fair. In addition, the petitioner submitted that although public participation was conducted in 19 counties, it was non-quantitative, non-qualitative, and therefore rendered meaningless. It was argued that public participation was conducted only in 19 counties, while the National Assembly executes its mandate in 290 constituencies. The petitioner has further argued that lack of proper public participation is evident from the reports of the National Assembly and the Senate. It was their case that the National Assembly and the Senate did not provide adequate opportunities for people's involvement in the legislative process of the Affordable Housing Act. In the same vein, the petitioner has also submitted that Kenyans had legitimate expectation that the Constitution would be followed in conducting public participation. In conclusion, the petitioners urge this court to find that the Affordable Housing Act did not meet the constitutional parameters for public participation under Articles 10, 118, and 201 of the Constitution. In their response to this question on public participation, the respondents did not dispute that public participation is a requirement of the Constitution. To illustrate, the National Assembly indicated that it conducted civic education in languages comprehensive to the diverse communities in various locations before public participation sessions were conducted by providing fact sheets that gave information to the affordable housing bill. In addition, advertisements in the local daily newspapers were done inviting the public to submit views on the bill by the deadline of 28 December 2023. Key stakeholders were invited to participate to make oral presentations before the committee, sittings that were held in Parliament buildings on 29 and 30th January 2024, 6th and 7th February 2024. The respondents admitted that public hearings by key stakeholders were held on diverse dates across 19 counties that included Narok, Kisii, Homa Bay, Vihiga, Uasin Gishu, Turkana, Baringo, Nyandarua, Nakuru, Machakos, Kirinyaga, Embu, Kiambu, Wajir, Tana River, Lamu, Kilifi, Mombasa, and Nairobi County. Additional meetings were held on various dates with the State Department of Housing, the National Treasury, and the State Law Office, among other government agencies, that allowed various agencies to make presentations to the joint committee. It is the National Assembly's case that it received and reviewed written memoranda submitted by the public and invited stakeholders. It is further the National Assembly's case that the majority of the stakeholders were overwhelmingly supported the bill, noting that promotion of investments in affordable housing has a multiplier effect on the economy through creation of employment, improved supply chains for the construction materials, and consequently will improve the general public. According to the National Assembly, the assessment of Parliament's compliance with its obligation to facilitate public participation in the legislative process is guided by the principle of reasonableness, and there is sufficient evidence to demonstrate that the Act was procedurally and legally subjected to public participation per the Constitution and the standing orders of the House. As a result, the National Assembly urged this court to find that the Affordable Housing Act was compliant with the provisions of Article 10 and 118 of the Constitution. The National Assembly and the Attorney General alleged that the question of public participation had already been determined by a court of concurrent jurisdiction in the case of Appeal versus Attorney General and two others, that is the Kisumu petition, on February 29, 2024, where the court found that public participation in respect of the housing bill was compliant with the provisions of the Constitution. The Senate also asserted that the public participation in the Act was conducted by the law and the standing orders, and there was no requirement for public participation in the 47 counties as alleged. It denied that senators were gagged from fully and freely debating the bill and argued that there was no proof provided to this court by the petitioners to discharge that duty. On their part, the KRA indicated that the rate of 1.5 was picked, which was picked from the Finance Act 2023, was on reasonable grounds that it had undergone proper public participation, channels, stakeholder engagement, and the rationalization process, which proposed a reduction of the rate from the initially proposed rate of 3% to 1.4%. It was their case that the High Court judges did not counter the constitutionality and validity of the rate in the petitions challenging the Finance Act. The respondents' assertion that public participation was conducted within the principles of the Constitution was supported by the 10th respondent. I think this is the 10th interested party, COFEC. It was the COFEC's argument that the public participation was conducted within the confines of the Constitution, and that the opinions of Kenyans with regard to the provision of the collection of the levy of affordable housing by the state were considered before the impugned law was enacted. Having considered the foregoing arguments, the report of this court first dispenses with the issue on public participation being res judicata in reference to the case of appeal. The respondents have stated that the issue of public participation at the National Assembly ought not to arise in this case, as the court already determined that it was compliant with the provisions of the Constitution. Conventionally, the doctrine of res judicata is designed to bring finality to litigation and to provide parties with closure and relief from the burden of being trampled or pursued in connection with issues and lawsuits that have already been resolved by a court of competent jurisdiction. And this is the holding in the Supreme Court in the case of Kenya Commercial Bank by Mwiri and Mwiri Coffee Estate Limited. I will not rehash what the Supreme Court said. The Supreme Court also reaffirmed on the side case and cited the case of John Florence Maritime Services and another was the Cabinet Secretary of Transport and Infrastructure, where it goes on to explain the principle of res judicata. The Supreme Court held that a court has discretion to the matter before it and determine whether it may occasion substantial injustice to the parties, and in the alternative, it must be convinced that there are special circumstances that allow it to make exceptions to the doctrine of res jurisdiction. This court has perused the appeal case and noted that the petition before the said court was pegged on the impugned notice dated 9th December 2023, issued by the National Assembly in the local dailies, requiring public participation by way of submissions of memoranda for the Affordable Housing Bill number 775 of 2023. The said court noted that the petition only challenged, this court noted that the petition only challenged this mode of public participation on the ground that marginalized communities or persons living in the slums of Korogosho, Mathare and Kibera were not able to submit memoranda in the manner prescribed. The court has also looked at the issues raised on public participation in the 6 petitions. Herein, vis-a-vis the issues raised on public participation in the appeal case, it is our considered view that the issues raised in the instant petitions raise a broader question as to whether public participation was conducted at the National Assembly and the Senate within the tenets of Article 10, 118 and 201 of the Constitution, while in the appeal case the issue was specific to the mode used to conduct public participation. In any event, the court found that the issue was not ripe for determination, as the National Assembly did not only require submission of memoranda but also held public hearings as a mode of public petition. And we've cited the decision at paragraph 47 and 48 and 73 of the appeal court. We find the circumstances that the issue of public participation is not res judicata, and now proceed to consider the issue substantively. It is undeniable that public participation is essential to the legislative and policy functions of government, both at the national and county levels. Public participation is integral to the legislative enactment process. Under Article 10(2)(a) of the Constitution, public participation is one of the key national values and principles of governance. Article 118 of the Constitution provides as follows: Parliament shall A, conduct its business in an open manner, and its sittings and those of the committee shall be in public. Facilitate public participation and involvement in the legislative and other business of the Parliament and its committees. Failure to ensure public participation is fatal. Any action requiring it that proceeds without such involvement is invalid, as it violates an explicit constitutional mandate. This was the holding in the case for Doctors for Life versus the Speaker of the National Assembly and others. I think this is a South African decision that is widely cited. We are certain that public involvement was crucial prior to the enactment of the Affordable Housing Act. Public participation must be authentic, not just symbolic, and should not be treated as a mere formality to comply with constitutional obligations. It is important, therefore, that this court answers what defines proper and reasonable public participation as envisioned in the Constitution. We cite the decision in the South African case of Minister for Health and another versus the New Clicks, South Africa, where the South African court held that the principles of fairness are not to be applied by rote identically in every situation. It cannot be expected of the lawmaker that a personal hearing will be given to every individual who claims to be affected by the regulations that are being made. What is necessary is that the nature of the concerns of different sectors of the public should be communicated to the lawmaker and taken into account in formulating regulations. End of quote. Public participation does not necessarily mean that everyone must express their opinions. Instead, there should be tangible evidence of a purposeful initiative to incorporate a variety of perspectives in the participation program. This was asserted in the case of Moiko Basin versus Moiko Basin local community and 15 others versus the permanent secretary, Ministry of Energy. And we cite a quotation where the court said public participation does not dictate that everyone must give their views on an issue of environmental governance. To have such a standard would be to give a virtual veto power to each individual in the community to determine the collective affairs. The question that must be answered by this court is whether an opportunity was afforded to the public to air their views on the implementation of the Affordable Housing Act. This is as per the threshold set by the decision of the Supreme Court in the case of British America Tobacco, PLC, versus the Cabinet Secretary for Ministry of Health, Kenya Tobacco Alliance, and another, and Mastermind Tobacco, where the Supreme Court in this decision said that, and I quote, public participation has been entrenched in our Constitution as a national value and as a principle of governance under Article 10 of the Constitution, and is binding on all state organs, state officers, public officers, and all persons whenever any of them A, applies or interprets the Constitution, B, enacts, applies or interprets any law, or C, makes or implements the public policy decisions. As aptly stated by the Appellate Court, public participation is anchored in the principle of the sovereignty of the people that permeates the Constitution, and in accordance with Article 1.4 of the Constitution, is exercised both at national and county levels. The court went further to reiterate this principle in the case of Aura versus Cabinet Secretary, Minister of Health, and the National Assembly has argued that the invited members of the public to take part in the exercise, which was conducted by the Joint Committee of the Department on Finance and National Planning and the Departmental Committee on Housing and Urban Planning, Public Works and Standing Committees on Roads, Transport and Housing, respectively. Both committees have demonstrated through their reports annexed as SN1 to the affidavit of Samuel Joroge, the clerk to the National Assembly, and JN1 to 3 of the Senate that support the assertions that the public and various stakeholders were invited and their views were taken into account before Affordable Housing Act was enacted. Herein below is a chronology as enumerated by the two affidavits that initial reading and committee referral that the Housing Bill number 75 was introduced to the National Assembly on the 7th of December 2023. The bill was subsequently referred to the Departmental Committee on Housing, Urban Planning, as well as the Departmental Committee on Finance and Planning. That on the 9th of December 2023, the clerk of the National Assembly published a notice in the local newspapers inviting the public to submit memoranda. This notice was issued under Article 118 of the Constitution and Standing Order 127 of the National Assembly Standing Orders, which require the House committees considering bills to facilitate public participation. That the National Assembly reached out to key stakeholders, inviting them to participate in public hearings held across the 19 counties on various dates, and this was not the only form of public participation, as there was nationwide collection of memoranda and public meetings in chambers of both houses. That from the 9th to 16th of December, the National Assembly collected public memoranda, which was collected nationwide. During this period, Petition 103 of 2023, that's the appeal case, was filed, leading to an order from the High Court in Kisumu prohibiting public participation as prescribed by the published notice on the 9th December, pending the determination. Subsequently, the High Court in Kisumu temporarily halted the collection of public memoranda, but this did not stop the other forms of public participation which were ongoing. On 17th January 2024, the High Court clarified that its order applied only to collection of memoranda by the National Assembly. On the 29th of February, the High Court in Kisumu ruled that the notice issued by the clerk of the National Assembly was valid, dismissing the petition. The court affirmed that the National Assembly had conducted public participation in a constitutionally compliant manner. This determination by a court of concurrent jurisdiction found that the National Assembly carried out public participation in accordance with the law. Based on the court's decision, it was concluded that public participation, that in the Kisumu case, had been properly conducted. We note that on the National Assembly extended its invitation to stakeholders through letters dated 11th, 13th, and 29th January 2024, requiring them to make oral presentations before the committee. These sessions were held on 29th and 30th of January 2024, as well as 6th and 7th of February 2024. We further note that the National Assembly that held consultations with various government agencies, including the State Department of Housing and the National Treasury and the State Law Office, offering opportunities for them to submit representations to the joint committee. This is to be found in the affidavit of Samuel Jeroge, clerk of the National Assembly. The National Assembly then reviewed the written memoranda submitted by the public and invited stakeholders. A report detailing this consideration was annexed to the affidavit of the said Samuel Jeroge and marked as SN1. The bill underwent the second reading on 15th February. During that time, debate by members of the National Assembly took place, discussing the nature and effectiveness of public participation. The ASAND report, which is annexed to the pleadings, details a report of the session of 15th February, which is attached to the pleadings here as SN2, the documents this discussion. The bill was passed with amendments on 21st February and subsequently referred to the Senate in accordance with Article 110 of the Constitution. We also note that in line with Article 118 of 1B of the Constitution and Standing Order 145 of the Senate Roads, Transport and Housing Committee invited the public to submit written memoranda. This invitation was published in the Daily Nation, the Standard and the Star newspapers on the 23rd February 2024. These submissions were annexed to the pleadings and marked as JN1 to the Senate's response by an affidavit by Jeremiah Nyengenye, clerk of the Senate. We note that the Senate conducted, through its Committee of Transport, Housing, also sent invitation to key stakeholders to appear before the committee for public hearings on 1st March 2024. The invitations were marked and annexed to the Senate's response as JN2. The Senate Roads and Transport Housing Committee reviewed the memoranda and stakeholder submissions. After considering various proposals, the committee's recommended that the bill be adopted with the proposed amendments. These views were annexed to the Senate's response, marked as JM3. On 12 March 2024, the Senate passed the bill with amendments. The bill was then transmitted to the President for assent, which took place on the 19th of March. It cannot be denied from the foregoing that the public participation was conducted. As shown, the National Assembly and the Senate focused on very targeted and specific stakeholders. In particular, the petitioners. We note that the petitioners took issue with the fact that the public participation for an act that was intended to affect all Kenyans was only conducted in 19 counties. And we gave due attention to this concern, noting that there is no requirement in the law that public participation in 7 countries. We've considered cases in other jurisdictions on the issue of the short public engagement period, and we note that that a short public engagement period can comply with the doctrine of reasonableness if it is adequate to the issue at hand, proportional to the level of public interest or urgency, and fair in ensuring that stakeholders have meaningful opportunities to participate. Court elsewhere and here locally have held that engagement periods must be flexible and proportional with overall context, that is urgency, complex, stakeholder readiness playing a significant role in determining reasonableness. Shorter periods may be permissible when combined with diverse methods of engagement, stakeholder awareness and proportionality to the issue scale, as demonstrated in the case of R versus Secretary of State for the Environment, ex parte Spathom. This is an English case against the Secretary of State for Environment, Food and and diverse forms of participation and stakeholder readiness. In the instant suit, we take judicial notice that the stakeholders had already been engaged extensively on the Affordable Housing Act and Affordable Housing Levy. Public participation was not only limited to the Affordable Housing Act, it has to be looked at holistically. Public participation was conducted in respect of the Public Finance Act, where the Affordable Housing Levy was originally introduced and anchored under Section 84 of the Finance Act. The Affordable Housing Act was also put through rigorous nationwide public participation, as shown by the affidavits of Charles Inga in Petition 181. The said affidavit produced annexures which were marked as CH1 that contained several documents that demonstrated public participation at different levels before the parliamentary process. Briefly, note that on the policy framework, the National Assembly and Senate actions are shown to comply with the doctrine of reasonableness through the following elements. That is the range of participation methods. That is, the Senate considered the public input, including incorporations of amendments that were subsequently adopted by the National Assembly. It shows that Senate gave proper weight to the contribution made by the public. This reflects professionality, ensuring that enough time and opportunities were provided for stakeholders to be heard and for their feedback to influence the process. We also note stakeholder engagement by the Senate and National Assembly, where made specific efforts to gather, where the two houses made specific efforts to gather stakeholder views through their committees on roads, transport and housing, as reflected in the Senate's Annexure JN3. This demonstrates that the Senate made efforts that its processes were inclusive, allowing key stakeholders to participate meaningfully in the legislative process. By directing the court's attention to the Senate demonstrated that it acted transparently in documenting and considering public input. This reinforced the fairness principle. Taking into account the principles set out above under Article 159 on the burden of proof, and in particular Article 159 of the Constitution on interpretation of the Constitution, we are satisfied, therefore, there was adequate public participation before the enactment of the Affordable Housing Act. The second issue that I'll consider is whether the Affordable Housing Act violates the rights to Article 27 and 40 of the Constitution. In respect of the above question, the petitioners argued that the collection of the levy is discriminatory, that while the Act is clear on the formal sector, that the formal sector is to be taxed on their gross salary, it did not provide for a structure on how collections from informal sector was to be made. We have cited the provisions of Article 27, which I don't intend to rehash, and go on to say that it is plain that while the Constitution in principle prohibits discrimination, it also recognizes in certain situations affirmative action that will be necessary to give full effect to the realization of the rights guaranteed by the Constitution. In this regard, we cite the case of Jacqueline Okeo Manani versus the Attorney General, where the court held that discrimination, simply put, is any distinction, exclusion, or preference made on the basis of difference to persons or groups of persons based on such consideration as race, sex, religious beliefs, political persuasion, or any such attributes that has real or potential effect of nullifying or impairing equality of opportunity or treatment between the two persons or groups. The Court of Appeal reiterated this principle in the case of Rawal versus the Judicial Service Commission, and it held, and I quote, discrimination is a distinction which, whether intentional or not, is based on grounds relating to person or character of the individual or group, and as effect which imposes disadvantages not imposed upon others, or which withholds or limits access to advantages available to other members of the society. Section 4 of the Affordable Housing Act provides as follows. 1, that there is imposed a levy known as Affordable Housing Levy. 2, the levy shall be at the rate of 1.5% of A, gross salary of an employee, or other gross income of a person perceived or accrued, which is not subject to levy under paragraph A. And 3, the levy shall be payable to the collector for remittance into the fund, not later than the 9th working day after the end of the month in which the gross salary was due or gross income was received. The petitioners impugned the above provisions and submitted that it is discriminatory in as far as it only gives a framework on how the levy will be collected from the Kenyans in formal employment as compared to the Kenyans in the informal sector, contrary to Article 27, 1 and 4 of the Constitution. It was further their contention that enforcing a mandatory uniform deduction it directly discriminates against individuals whose own homes are paying mortgages, have no interest in the scheme, or are low-income earners. Section 2 of the Employment Act defines an employee as a person employed for wages or salary, and includes an apprentice or an indentured learner. Section 3 of the Income Tax provides for who should pay taxes, and we have lifted the entire Section 3, which is quite lengthy. I don't intend to rehash it. From my understanding, an employee, for purposes of the Employment Act, is a person who is employed for wages or salary, and is therefore under an obligation to pay tax under Section 3(2), cited above of the Income Tax Act. The court acknowledges that collection of tax in the informal sector may impose difficulties to Kenya Revenue Authority. However, it is instructive to note that Section 52B of the Income Tax, Chapter 470 of the Laws of Kenya, The Kenyan system of self-assessment, the Kenyan system is of self-assessment, which provides that where a taxpayer assesses himself or herself and makes payments to KRA. I've cited section 52B, which I don't intend to rehash, and I go on to state that in this regard, the court referred to the case in the Commissioner for Domestic Taxes versus Galaxy 2's, this is income tax appeal number E088 of 2020, where the court observed as follows, that this country operates under a self-assessment tax regime. Under this regime, the taxpayer assesses self and declares what he considers to be taxable income, on which he then pays tax to the authorities. For this reason, tax laws are couched in a manner that gives tax authorities wide powers and discretion in ascertaining ex post facto what taxable amount is. It is therefore our finding section 4 of the Affordable Act is not discriminatory and does not infringe on Article 27, Sub-Article 1 and 4 of the Constitution. The mode of collection of the housing levy as provided for by the Act is indeed different but the same and does not amount to discrimination as alleged under section Article 27, 1 and 4 of the Constitution. Another dimension that the petitioner's argument was that the introduction of the levy and the fact that it has been set at 1.5 of the gross salary was an infringement of Article 40, Sub-Article 1 and 2 of the right to property. And we have cited Article 40, Sub-Article 1 and 2, which says protection of the right to property, subject to Article 65, every person has the right, either individually or in association with others, to acquire and own property of any description in any part of Kenya. 2, Parliament shall enact a law that permits the state for any person to A, arbitrarily deprive a person of property of any description of any interest or right over any property of any description, or B, limit or in any way restrict the enjoyment of any right under this article on the basis of any of the grounds specified or contemplated in Article 27A. 4. The petitioners were of the view that the levy introduced an extra burden on the taxpayer, contrary to Section 19.3 of the Employment Act. We've cited Section 19.3b. The respondents in their rebuttal claimed that the imposition of the levy will not have the effect of reducing the net income of workers whose net pay is just 1/3, and increasing the deductions of their wages above 2/3. It was the respondent's case that nothing was placed before the court to show that the levy would be a heavy burden on the taxpayers. The respondents justified the housing levy as a commendable initiative aligned with the Constitution, as it is aimed at ensuring that Kenyans have access to affordable housing, a move that is aimed at ensuring that every Kenyan enjoys the right to accessible and adequate housing and to a reasonable standard of sanitation as guaranteed under Article 43(1)b of the Constitution. Taxation in Kenya is based under Article 209 of the Constitution, which empowers the national government to impose income tax, value-added tax, excise duty, custom duties on imports and exports, and any other taxes prescribed by an act of parliament. Article 209(2) deters the imposition of a tax or a duty that have been specified in Clause 3A and B, being property rates and entertainment taxes that are to be imposed by the county governments. It is a widely recognized judicial principle to respect the constitutional authority of the body entrusted with a particular function without unnecessary interference from the judicial branch of government. The court in the case of Duku versus Kirori versus County Government of Murang'a held as follows: moreover, where a statute or the constitution for the matter has explicitly delegated specific functions, duties, or responsibilities to particular organs, state or otherwise, this court will be hesitant to intervene and curtail these organs' efforts to exercise their statutory or constitutional mandate. It is the duty of this court to interpret the Constitution in a purposive rather than a restrictive manner. End of quote. Article 210 of the Constitution provides that no tax or licensing fee may be imposed or waived, varied waived or varied except as provided for by legislation. In essence, there must be legislation that supports the imposition of any tax or licensing fee. Without such a legal framework, any imposition of tax by either the national or county government would be unconstitutional. This was reiterated in the case of Cereal Growers Association and another versus the county government of Narok, where the court found that a tax must be imposed based on legislation and administered in accordance with a certain legal framework, and to my mind, therefore, tax cannot be an administrative decision. End of quotes. In the present case, the legislation is the Affordable Housing Act that established a levy known as the Housing Levy under Section 4.1. It is our finding that the levy is properly in place and is in accordance with the Constitution. The next question that we pose is whether the imposition of the levy infringes on the rights of Kenyans as alleged by the petitioners. The petitioners contend that the levy of 1.5% on gross salary is not only ambiguous, but was also not premised on empirical study to show that operating the fund in any financial year or for any period would cost and that the revenues to be raised by the levy at that rate are required. Section 4.2a of the Act provides that the levy shall be at the rate of 1% of the employee's gross salary, while Section 4.2b of the Act provides that the levy shall be at the gross income of a person received or accrued, which is not subject, sorry, I've lost myself, to the levy under paragraph A. Petitioners argue that Section 4.2b does not give a clear legal framework on how the levy shall be collected from persons working in the informal sector. This question was adequately attended to earlier and addressed at a paragraph 362 above and 365 on self-assessment of the tax regime. The respondent's response to the petition's concerns was that Section 4.2b, as enacted, gives clear guidelines on how the levy is to be collected from Kenyans with no formal work. Under Article 95 of the Constitution, it is clear that the National Assembly enjoys broad powers to levy taxes and to determine the rate thereof, provided that such powers are not exercised in a manner that infringes on the Constitution. Article 201 of the Constitution sets out the principles that guide all aspects of public finance in Kenya. In Article 2.1, the Constitution provides as follows. The following principles shall guide all aspects of public finance. 2b, the public finance system shall promote an equitable society, and in particular, the burden of taxation shall be shared fairly. B, revenue raised nationally shall be shared equitably among national and county governments. And 3, expenditure shall promote the equitable development of the county.
Perhaps before you give the directions, my line of friend is Kimoto. She's informing me that she was not aware of directions in the morning, that applications be filed and they come back before you. And now her petition has been integrated in the consolidated petition. That is petition number E013. Therefore, she's not been able to file an application either for recusal or for challenging the empanelment. She was just requesting if she can be served with those applications and the responses, and she'll be given time, 1 hour just like the others,